Good morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime, where we cover some of the most interesting live trials in the country today. And I'm so happy you're joining us because we have a very busy day for you. I have so much to talk about. There's a lot on the docket. Are you ready? Are you? Well, here we go. Let's start off with the main case that we're going to be covering today. We are going back into the William Riley Gaul case out of Tennessee. We will have a live feed in about an hour in that case, but there is so much to talk about. Now, for anybody just joining us, the William Riley Gaul case is a case out of Knoxville, Tennessee. This is a former Maryville College football player who is on trial for allegedly stalking and killing his 16-year-old ex-girlfriend named Emma Walker. You see the two of them right there. She was a high school cheerleader. This happened back in November of 2016. It's alleged that Gaul fired 2 shots through Walker's bedroom wall while she slept, and one of those shots ultimately struck her in the head, killing her instantaneously. Now, what we saw yesterday was some pretty interesting testimony. First, it should be noted that some of the witnesses were minors, which means we couldn't show their testimony. We were not permitted to do so. But what we ultimately learned from those witnesses, as well as the witnesses we could show, was that the main conversation yesterday was about trying to understand the actions of the defendant before the shooting. And let's not forget, he is on trial for a multitude of different crimes, including stalking. And one of the things that came out was whether or not he created a fake kidnapping plot to get the attention of Emma Walker while she was at a friend's house to try to get her outside. There was allegations that he was dressed in all black stalking her in the days before the shooting. This conversation came out yesterday. We're going to talk more about it today. This case has a lot of different interesting parts, and I don't want to miss anything. So we'll talk about the William Riley Gaul case in a minute. I do want to let our viewers know that we are also carefully monitoring a new case here on Law and Crime, and I want to preview it for you today. There is a potential sentencing hearing in the Gloria Williams case out of Florida. Some of you might have heard about this case. It's the baby kidnapping case. So back in January of 2017, Gloria Williams was arrested for kidnapping a baby named Alexis Meningo. She named her Alexis Meningo. She was actually born Kamaya Mobley. She's 20 years old now. Now, what happened was Williams actually admitted to kidnapping Kamaya from a hospital when she was born, just hours after she was born. She posed as a nurse. So she actually pled guilty to a kidnapping charge, which is a felony 1 count, and an interference with custody count. That's felony 3. What will happen today is the sentencing hearing. And we believe it's going to last about 2 days, and the judge will render her decision in a couple of weeks. The interesting part about this is that Kamaya, this 20-year-old girl, the very focus of this entire case, she may provide testimony about what she thinks should ultimately happen to her mother. I guess that's one way of saying it. I mean, for her whole life, she thought this woman was her mother. It's a tragic case, a sad case, and now we have to understand what will happen to Gloria Williams, the person that took this baby, but ultimately raised her. And from all accounts, it doesn't seem to be a situation of abuse or anything like that, which does raise a unique perspective about this baby kidnapping case. So that's another case that we're covering here. But let's also talk about one other case, 2 other cases I have for you. I lied. First, before I get back into the Sean Great case, which I'll talk about in a minute, I do want to let our viewers know if you go to lawandcrime.com today, we will be having a feed into the David Copperfield case out of Las Vegas. Remember, the magician as well as the MGM Grand are on trial right now. They are being sued by a man named Gavin Cox, who was an audience participant in one of David Copperfield's magic tricks. He got injured. He's blaming and suing David Copperfield as well as the MGM Grand for negligence. We've been covering that case. You can go to lawandcrime.com. We'll have a live feed into that courtroom. We're not going to be covering it here on the network, but you can go onto our website to follow more about that case. So that's the David Copperfield case out of Las Vegas. Now, let's talk about our other main trial that we've been covering, and it's on break today. It's not coming back till next week, I believe, until Monday. This is the Sean Great case, okay? Everybody knows about this case. We've been following this case every day. For anybody who doesn't know, this man that you see right there, he is on trial for 23 counts. He's an alleged serial killer. The primary crux of this trial is about the murders of 2 women, Elizabeth Griffith and Stacey Hicks, as well as the abduction and rape of a 3rd woman named Jane Doe. Yesterday, ladies and gentlemen, this man, the man that you see right here, he pled guilty to 15 counts in that 23-count indictment. You heard me correct. In the middle of the trial, he went to the judge and pled guilty to everything from gross abuse of a corpse to burglary, tampering with evidence, rape, multiple counts of rape, kidnapping, burglary. I want to show you right now, before we really get into the analysis of this case, I want to show you yesterday when Mr. Great pled guilty to these 15 charges. Take a look. You get the idea. He pled guilty to 15 charges, ladies and gentlemen. So let's try to understand why. Why would this happen? What is he still on trial for? That's what we want to talk about. Joining me right now on set is criminal defense attorney Randy Zelin. Randy, good to see you.
Good morning.
So he pled guilty to a lot of different charges, and this is everything from gross abuse of a corpse, burglary, tampering with evidence, multiple counts of rape, unauthorized use of a vehicle, kidnapping, breaking and entering, but he did not plead guilty, and what he's still on trial for is the kidnapping and murder of Elizabeth Griffith and Stacey Hicks, or Stacey Stanley, and also the robbery of Stacey Stanley. What exactly is going on here from the defense's strategy?
Well, let's work backwards. He didn't plead guilty to the most serious offenses because those most serious offenses could get him the death penalty. So it's the old, you deny what you dare not admit. From a strategic standpoint, and to answer your question, why would you plead guilty in the middle of a trial? It is, in my opinion, because this trial is not about if he did something really bad. It really is more a matter of should he pay the ultimate penalty for it? Should he be executed? The rape, for example, that he pleaded guilty to, as I understand it, the evidence that would come out at the trial, if he were on trial for rape, would include videos of the rapes. From a defense standpoint, you want a jury watching you raping someone as if they were standing there watching, like you want to get the death penalty. And since that act would be an aggravating factor for the jury to consider on the question of whether or not to recommend the death penalty, by pleading guilty to the rape, for example, in my opinion, the judge now will not permit the prosecution to play those rape videos. There's no reason for it. He's already pleaded guilty. All that would do at that point would be to prejudice the jury, as opposed to having some, what we call, probative or an evidentiary reason.
In other words, they would be so inflamed by seeing these videos. And by the way, if you go to lawandcrime.com, our very own Aaron Keller wrote a great article about this. But what the videos would have been with one video of an unknown woman being raped, 2 videos of victim Stacey Hicks being raped, and 9 to 10 videos of the surviving victim, Jane Doe, being held against her will and raped. So if the jurors were to see this, and now they have the power to determine what happens to him, you're saying that could unfairly prejudice them.
Not even unfairly, it's game over.
Game over.
Again, because whatever you want to say about this man as his defense attorney, in mitigation, if he's convicted of the murder charges that could carry the death penalty, all of that will be undone. You could talk about his childhood, you could talk about his life, you could talk about whatever mental defects.
Yeah.
But if you allow the jury to watch that video, I think it's pretty safe to say he's not going to come off in anything other than having been an absolute monster.
Randy, where are we right now? So the case, the Sean Great case, ladies and gentlemen, is on hold till Monday. Both sides have rested. The defense called no witnesses. They did not provide an opening statement, and they did very little cross-examination. We expect closing arguments in the guilt phase on Monday. Now, we remember, when telling our viewers, this case is split up into 2 parts, the guilt or innocence phase, and then this sexual violent predator specification phase. What is going on in this case? What can we expect beginning next week?
Assume again that the defense strategy is not to get an acquittal. The defense strategy is to save this man's life. I am his defense attorney, and I make a decision. And remember, trial practice is not math. 2 plus 2 does not equal 4. It is an art. It is feel. And only in hindsight, oftentimes, will you know if you made the right decision. And much like we saw in the Boston Marathon bombing case, where the trial strategy from the defense was, we're not going to focus in on getting an acquittal. We're not going to insult the jury's intelligence. We're not going to try to pound a square peg into a round hole. Let's focus on saving his life. And in my opinion, what the defense is doing here is they basically said, the hell with winning the case from getting him off. Let's win the case and not have him get the death penalty. So let's not get the jurors angry. Let's not get them annoyed. Let's not get them, hey, what are you people kidding me? Let's have credibility with them.
Right.
Now, credibility will come into the penalty phase, where we now present to them reasons why, mitigation, good reasons why he should not die.
And I can imagine that'll be everything from him having a teenage son to him having some sort of suffering from some sort of mental disease or defect. That is really where I believe, and I think you would agree with me, the defense will really begin their arguments in a way.
The defense is choosing their battles wisely.
Yes.
If you fight every battle, then you are incredible unless you win every battle. And then
I'm
you are
surprised.
incredible.
Coming from an attorney? Come on, you don't fight every battle?
I do not.
I feel disappointed to hear that.
I do not.
Now, Randy, stand by. This is not the only case that we're covering here. As you heard from the top of the hour, we are covering a lot of different cases. And I want to talk about our main live trial of the day, although we will also be hopefully in the Gloria Williams sentencing hearing. We are going to be talking about right now the William Riley Gaul case out of Tennessee. This former star football player who's on trial for allegedly stalking and killing his 16-year-old ex-girlfriend Emma Walker by shooting her from outside of the bedroom window. And this is a really sad case. What I want to play for you right now is a short summary of the opening statements where you can understand what this case is about and how each side is going to argue it. Take a look. All right. Not exactly what I wanted to play, but that's okay. Stand by. We'll talk about this case in a minute. As soon as we have that report, we'll make sure to go to it. Again, I'm here with Randy Zelin, criminal defense attorney. This case is interesting. I find this case interesting. And from one perspective, you could look at the prosecution and say they have a slam dunk case. I mean, they have the guy, he fired a weapon. He pled guilty to the count of firing a weapon at a home. But 2 shots. One of those shots hit her directly in the head, and he didn't see her when he fired the gun. He shot from outside the home. As a defense attorney, is that something they can play with, that fact?
I see this case as anything from as a slam dunk from the perspective of, was it an intentional murder case? And as we talked about a moment ago, this notion of trying to fight every battle, once again, in my opinion, in this case, the prosecution is overplaying its hand, and they're going for too much.
You really believe that?
I don't know how anyone can argue with a straight face that by firing a gun from the outside of a house into the house is evidence that I intended to kill someone.
Well, I'll press you on that.
In the house.
Why would he fire the gun then? Why would he fire? He knew where her bedroom was. Why would he fire the gun right there? Why do that?
Because unless he has X-ray vision, there is no way, in my humble opinion, an argument could be made that he intended to kill her. For all we know, that's exactly what he pleaded guilty to, which is what I did was incredibly stupid. By firing a gun into the house, I closed my eyes to the high probability that I could have hurt someone or killed someone. No different than if I walk into a movie theater and fire a gun into a movie theater. Does that mean I'm intending to kill someone in the movie theater? No, but I've closed my eyes to the high probability that something bad could happen. Shooting, if he shot her in her room while he was in her room, different story.
So you're saying this is more of a manslaughter charge?
Absolutely.
Okay, so what about the defense's theory here that, okay, this is a guy, 18 years old, He was engaging in really odd behavior. They had a tumultuous relationship. He loved her. He wanted to show up as her knight in shining armor. I don't know how much a jury is going to buy that, in the sense that he was trying to protect her at times and be there for her. It seems like you have a person who was unhinged and went off the deep end. If I was sitting on the jury, how do you fight against that? How is the defense presenting a strong argument there?
I think, and I hope what they're trying to do is build to the point of, yes, this was a teenager, and let's keep that in mind, a teenager. Brain not fully formed, the ability to be mature and make good decisions, you're not there yet. Now you inject love, and someone who's unhinged probably to begin with, now factor in love and rejection. Lord only knows how the wheels fall off the bus. But once again, the defense, in my opinion, should not be trying this case for an acquittal. What they should be trying this, or a complete acquittal, run the table. And clearly they're not, because he pleaded guilty to the reckless endangerment. The strategy should be beat the most serious count. Show to the jury without him even having to testify. I've already testified. By admitting my guilt, I basically told you what happened. And I'm not insulting your intelligence, and I'm not going to, again, try to pound a square peg into a round hole or dare the prosecution to prove my guilt. I've admitted to you what it is that I did, and what I did is consistent with everything that's being portrayed about me. I shot into the house not intending to kill her. Whether I shot into the house because I momentarily lost my mind, or I shot into the house because I wanted them to call 911, and I would show up at the scene saying, let me help find out who did this. That is a far cry from forming the intent, maybe even a moment before, I'm going to shoot through not just a wall, shoot through the entire house, intending to kill her. That to me is a dog that doesn't hunt.
Well, ever since the Tex MacGyver case, I never know what to expect, so we'll have to see. But let everybody, this is the case that we're covering. We're covering the William Riley Gaul case. We're expecting a live feed in about, 40 minutes or so. As soon as we have it, we'll make sure to go into it. He is charged with first-degree murder, stalking, theft of property, hiding a gun, employing a firearm during a dangerous felony, killing during aggravated child abuse, which is a little bit like the felony murder rule. We'll talk more about that in a minute. And he did already plead guilty to reckless endangerment, and that was by firing a gun into the home, into a home, excuse me. And he faces anywhere from 3 to 15 years in prison with a fine up to $10,000. So that's already on this table for him. That's already set. Now it becomes the question for the defense, how do they argue away the rest of those charges? What I want to do right now is play for you some of the testimony from Emma Walker's mother, and you can imagine how difficult this must have been for her on the stand. Take a look. This is testimony from yesterday. That was the testimony of Jill Walker, Emma Walker's mother. It was from yesterday. Remember, Jill Walker discovered that her daughter was dead, and one of the chilling aspects of this case, in the William Riley Gaul case, she didn't know that her daughter was initially shot at first. Let's talk a little bit more about that with Randy Zelin. Randy, that's a really chilling detail. The fact that the family walks in, they initially thought that she might have vomited. They didn't realize it was a gunshot wound, because let's not forget, according to the way that what we know so far, this gunshot allegedly went off at 3 a.m. There was an air conditioning unit outside. It suppressed the shot. They didn't really hear it. Imagine for her to go in, see her daughter unresponsive and cold, and then only later to realize she was shot.
It's awful, but it really doesn't have any place in the courtroom. It's irrelevant to any burden of proof that the prosecution has.
Can't the defense play with that and say, listen, so if no one saw the shot or if it was suppressed, how do you know?
You can do that without bringing up the fact. It's unspeakable.
So you would have objected and said it's not irrelevant.
What I would have done is I would have asked, and for all we know, they did ask for a hearing in advance of the trial to keep that testimony from coming out, because it does you no good to object in the middle of the trial, because the question's out, and if the witness starts to answer, you can't put that toothpaste back in the tube. So what you want to do, at least for my money, that is such a horrible visual. But it's irrelevant. It is not an element of the crime. It is not part of the prosecution's burden of proof. all it is sure to do is make the jurors sick to their stomach, which invariably translates into prejudice. Imagine, what would be the difference if the jury never heard the fact that this poor woman walked in, sees her daughter unresponsive, thinks that she vomited, and it turns out it's her brains and her blood and not vomit. How does that matter if you left that out? Does that change this case at all? Could the prosecution say that's not fair to us because it makes our job harder? Of course not.
But doesn't that just tell the story of how her body was found, how this all unfolded? I mean, isn't that important to it?
No.
Really?
No. Unless someone's going to say she wasn't dead. Look, unless the defense's theory is, look, she wasn't dead when you walked in there. And the fact that you didn't immediately get her attention and get her help, that led to her death. And that's not something that you should lay at our doorstep. It's not a great argument, but it's better than no argument. But in this particular instance, it's completely irrelevant as to what the mother saw and the mistake that she made thinking that her daughter vomited.
Right.
It doesn't matter.
Yeah. I mean, it's hard. You made a really good point. It's hard to undo what the jury hears. So let me ask you just a general question about that. Even if there's an objection and you tell the jury, strike that, don't listen, they listen to everything, right? As soon as you introduce it, they can't forget it, right?
Yeah, which is why, quite frankly, there are times that you ask a question, it's going to get objected to.
But you want them to hear it nonetheless.
Even just hearing the question.
Right.
Sometimes the question is as powerful as the answer. And in fact, if you really want to be cute as a trial attorney, you ask the question, objection, I withdraw the question.
Right.
It's too late.
Look at that. Good trial practice, ladies and gentlemen. You're getting great trial practice here on Law and Crime. So as you know, we are covering the William Riley Gaul case. For anybody just joining us, this is that former star college football player who's on trial for allegedly stalking and shooting and killing his 16-year-old ex-girlfriend, Emma Walker. We're talking about the testimony from yesterday. What I want to play for you right now is some of the testimony from the defendant's grandfather. And remember, it is alleged that Mr. Gaul stole... Welcome back, ladies and gentlemen. That was the testimony of James Walker, the grandfather of the defendant in the William Riley Gaul case out of Tennessee. We've been covering that case. We're going to be live in that courtroom today. Again, that prominent college football player who's on trial for allegedly stalking and shooting and killing his 16-year-old ex-girlfriend, Emma Walker. We'll talk more about that case in a minute. But I want to switch gears right now because, as you know, we have a busy day. We are also going to be live in the Gloria Williams sentencing hearing out of Florida. Remember, Miss Williams was arrested for kidnapping. She was arrested and pled guilty to kidnapping a young baby, a baby that was born literally like hours before, stole her from a hospital. Her biological name was Kamaya Mobley, but she named her Alexis Manigo. And this horrific situation is actually not as sad as it could have been, because from all accounts, while this kidnapping was terrible, according to Miss Mobley, who's now 20 years old and we believe will provide testimony in this hearing, she had a good life. She had a good life with Miss Williams, but Miss Williams did plead guilty to kidnapping and interference with custody, and now it begins the sentencing hearing. What will she be sentenced to? And it should be noted that Williams is asking for between 0 and 22 years in prison on the kidnapping charge and 0 to 5 years in prison on the interference charge. Let's talk a little bit more about this with criminal defense attorney Randy Zelin. Randy, this is a different perspective in the sense that you have a kidnapping, but there doesn't seem to be any abuse. There doesn't seem to be any violence. It seems to be someone took a baby, raised her. Miss Mobley thought that this was her actual biological mother. And it was only until last year when the truth came out. So this has a lot of bizarre details to it. But what do you make of the sentencing hearing today?
I think there are a few things that are noteworthy. First of all, you have the question, why would this woman plead guilty to such serious charges? And the answer to that is, as you just indicated, in her plea agreement, there is no minimum mandatory. She can get 0 time. So, since we always talk about the importance of having a game plan and having a strategy. Here, it appears to be that the defense's strategy is, once again, we're not trying to run the table. We're not trying to win on the issue of wrongdoing. Did I commit a crime? Did I not? That battle, they concede. What they are going to focus in on is sentencing. Now, sentencing is not simply about punishment. That is only one piece of it. Certainly, as you said, this particular case really puts the notion of sentencing on trial, because on the one hand, when you first say the words, this woman stole a newborn baby, at that moment, as a human being, you're likely to shut down and say, listen, this woman should be punished, and her unborn great-grandchildren should be punished. This is unbelievable. But, as you said, keep going. This is not your typical kidnapping case, because the star witness for the defense is going to be the victim, is going to be the daughter, who's going to presumably get on that stand or get in front of that judge and say, Judge, I've had a great life. She has been a great mother. She has given me everything. I understand that what she's done is insane. But please, on the question of sentencing her, she's been a really, really good mother. And as a judge, I'm really going to be torn, because on the one hand, I have the biological parents whose lives have been, I don't know how you function. Can you imagine you have a baby and the baby's gone? Every day you must wake up wondering, is this a nightmare? You wake up every day, maybe she'll come back to me? So from a judge's standpoint, you've got to look at the parents, the biological parents, and say they deserve justice.
Then here's the question I have for you. Why is there a mandatory minimum? I want to make sure I said this right. The mandatory minimum, there's no mandatory minimum. It's zero. She could face no jail time.
Correct.
Isn't this the prime case for that? Why have a kidnapping charge where you might not face any jail time? Why have an interference with custody charge if you're not going to have any jail time? And here, isn't this the perfect example? Someone took someone but treated her perfectly. I mean, again, we'll learn more about it during the sentencing, but if that really is the case, and she raised her well and didn't harm her and was a good mom, isn't this the prime example for her not getting any jail time?
Well, certainly as a defense attorney, I would argue that there is no useful good in sentencing this woman to jail, and there's even less useful good in now punishing the daughter. Again, she's going to lose her biological mother, and now she's going to lose her, I hate to use legalese, de facto, which is, okay, I'm not legally, but for all intents and purposes I am. And now lose her for all intents and purposes mother? That's how I would argue as a defense attorney. As a prosecutor, I would say, Judge, look, I get it. That's great. But this woman needs to be punished severely. 2, deterrence. We can't have a justice system that says you can commit a really bad crime, but if after you commit that really bad crime, you're good to the victim of the crime, then you should get a pass.
Yeah. Randy, I'm going to throw a little wrench in this. I've just gotten an update. It's possible that Kamaya, this 20-year-old girl, may not testify now. Locals are saying she may not testify, even though it was the original understanding she would provide testimony. Even without her testimony, I'm sure there's going to be evidence put forward by the defense showing that she lived a good life and trying to show that, but not having her testify now, if that's really the case, and that's our update stays true, that really is that's a problem for the defense.
That's a huge problem, assuming that there's not some good reason. For all we know, she could be submitting letters. For all we know, there could be a legitimate and justifiable reason that will not impact the defense negatively. I don't think that that's the case. That's a pretty serious development, and I think if that in fact is the case, much like we saw in our earlier case, the importance of keeping the rape video out so you don't get that visceral reaction from the jury, not having the child in front of the judge, face to face, eye to eye, telling the judge and recounting for the judge in real time what a wonderful life this child has had, yeah, I think you could pretty much cross off 0 at the bottom end of a sentence.
There's so many bizarre details about this case, and I'm sure the fact that she posed as a nurse to take the baby is not something that will look good in her favor. But on the other hand, it should be noted that Craig Aiken, who is Kamaya Mobley's biological father, he wrote a Facebook post that said, there's feelings and emotions on both sides here, so it doesn't matter what I say. There's a possibility that I could hurt somebody's feelings either way. The whole situation is crazy. And really, the situation is crazy because if you look at it from a perspective, what was going on in her mind when she took that baby, posing as a nurse, these are facts that can really hurt her. Whereas today, in 2018, we're looking at everything she did since the kidnapping, and it seems that she raised a pretty great young lady. So it's an interesting back and forth between the prosecution and the defense here, I'd imagine.
Yes, so you could really do the Solomon routine and say, okay, 0 on the bottom end, 22 on the top end. I'll give you 11. We'll call it a day.
Maybe what happens. That may be what happens. Again, I'm here with Randy Zelin. We're talking about a lot of different cases here on Law and Crime. We will update you in the Gloria Williams case as soon as we have more and as soon as we have a live feed in that courtroom. We'll make sure to go to it. It is out of Florida. But right now, let's go back. We're going back to Tennessee. We're going to the William Riley Gaul case. We've been showing you the testimony of James Walker. This is the defendant's grandfather. And remember, according to the theory of the case, Mr. Gaul stole the weapon that he used in this shooting, that he allegedly used in this shooting to kill Emma Walker, stole it from his grandfather. We're learning a little bit more about their relationship, the gun, how this all unfolded. Let's continue playing some more testimony from yesterday. Take a look. All right, everybody. So that is some more testimony from the William Riley Gaul case. We're going to be live in that case today, and we're going to be in that courtroom. We don't want you to miss anything. Again, I'm here with criminal defense attorney Randy Zelin. The testimony from the grandfather, and again, he's not the biological grandfather, married the biological grandmother, but, it can't be easy when you have a family member or somebody who's so close to the defendant who is providing some incriminating testimony against his grandson. It can't be easy for him, and it can't be easy for I would say both sides to try to either during direct examination or cross-examination.
I think two things come to my mind. First of all, I think that ultimately the defendant is going to be punished significantly by the jury for putting his grandfather, biological or not, through that agony. You can see it on the man's face. He doesn't want to answer these questions. He doesn't want to tell the truth, but he raised his right hand and he swore to tell the truth. And you can see the pain, and you can watch him measure his words and hesitate before he answers, because he knows the answers to those questions are going to significantly hurt his grandson. And I think that that is going to make the jurors very, very uncomfortable. But there's something about the testimony that really I'm troubled by, because, again, we always talk about the defense having a strategy. And sometimes the strategy is, I don't have a strategy. The burden is on the prosecution. I'm going to shut my mouth and just punch holes and hope that the jury determines that, you know what, we need more information. We have a reasonable doubt. But since we know that the defense's theory here is that the gun and firing the gun was not intended to kill her, and therefore I should not be convicted of first-degree murder, then what is all of this stuff going on with the gun? Just concede the gun. And concede I took the gun from my grandfather because I wanted to do this ridiculous thing, but never, ever did I form a thought in my mind that it was my intention to kill this girl, because that's premeditation and that's first-degree murder. To me, it's almost like if I'm sitting in the jury, I'm like, why are you insulting my intelligence with this?
How would that work? You're saying the defense would say, let's concede the point. Let's say that he stole the gun from the grandfather, took the gun, but then the prosecution would concede the fact that I'm confused in the sense that you want the defense to say he did fire the weapon into the house. He admitted he pled guilty to it, but it's a manslaughter charge. It's not a murder charge, and you're hoping the prosecution will meet them halfway?
It's not that. What I would do is, as a defense attorney, first of all, I would go to the judge and say, Judge, look, do we really have to put the grandfather through all of this agony? We'll concede that the gun was taken from the grandfather.
But why was it taken? To fire a gun at a house, or because he wanted to kill her?
Because in a moment,
really is the big
in a
issue.
moment of craziness, the prototypical definition of heat of passion.
But it's not heat of passion if he stole the gun.
No, but it's part of the insanity, but not part of the premeditation to kill her. He closed his eyes. That's the definition of recklessness. I closed my eyes to the high probability that I could hurt or kill someone. If I walk into the studio right now with a gun and I fire the gun into the air, or I fire the gun to a wall and someone gets hurt or someone gets killed, that's not premeditated murder.
But if I'm in the jury, wouldn't I want to know why you took the gun? Where did it come from? I want to know the beginning of the story.
You can stipulate to all of those things and say to the judge, Judge, why can't the prosecution just stipulate? Or what I hope they'll do is, when comes time to cross-examination, I would throw the grandfather softballs. I would not attack him. Mm-hmm. I would not hurt him. I would not make him feel anything other than, we appreciate the fact that this is difficult and that you're here to tell the truth and you don't want to do anything to hurt your grandson, and I would sit the hell down.
It's not an easy case to analyze from any perspective, let alone the jury, which they will ultimately have to do later when this case concludes. We are going to take a short break. When we come back, we're going to talk more about this case, the Williams case, maybe even more of the Great case. We have a busy day here on Law and Crime. We'll be back in a minute. Stay tuned. Welcome back, everybody. So we're covering the William Riley Gaul case out of Knoxville, Tennessee. We're waiting for a live feed in the courtroom. As soon as it starts, we'll make sure to go to it. Again, this is that case of that former Maryville College football player who's on trial for allegedly stalking and killing his 16-year-old ex-girlfriend, Emma Walker, who was a high school cheerleader at the time of her death. It's alleged that Gaul fired 2 shots through Walker's bedroom wall while she slept, and one of those shots ultimately struck her in the head, killing her instantaneously. Now, what we are talking about right now is the testimony from yesterday of James Walker. He is the grandfather of the defendant, and according to the prosecution's theory, Mr. Gaul stole the gun, the very gun that was used in this shooting, from his grandfather. And it should also be noted that Mr. Gaul faces several different charges, including theft of property, so theft of the grandfather's gun, as well as hiding the gun. Now, Mr. Gaul also faces first-degree murder charges, as well as a stalking charge and a employing a firearm during a dangerous felony charge, as well as killing during aggravated child abuse. He did already plead guilty to reckless endangerment by firing a gun into the home. That guilty plea carries with it 3 to 15 years in prison and a fine of up to $10,000. So, as we can already confidently say, Mr. Gaul will already receive some jail time, but the question is, what will the remainder of his life look like? That's what he's on trial for, and that's what we're analyzing. I want to play some more of the testimony from James Walker, and when we come back, Randy Zelin and I will talk a little bit more about this case. Take a look.
When you get home, what do you do?
Welcome back to Law and Crime, everybody. One of the great things about this show is that we are in courtrooms throughout the whole country. And right now, you are looking at 2 feeds into 2 separate courtrooms. That's right. On the top, you have the live feed into Tennessee, into the William Riley Gaul case. And remember, this is that former Maryville College football player who's on trial for allegedly stalking and killing his 16-year-old ex-girlfriend, Emma Walker. The bottom screen is the Gloria Williams courtroom in Florida. Remember, this woman, Gloria Williams, pled guilty to 2 charges of kidnapping and interference with custody in relation to when she stole a newborn baby from a hospital. She actually posed as a nurse at the time. That baby, who she named Alexis Menigo, but was born Kamaya Mobley, is now a 20-year-old woman. And what will happen today will begin her sentencing. What will she be sentenced to? She is asking the court from anywhere from, I want to make sure I get this right, She's asking for between 0, that's right, no jail time, to 22 years in prison for the kidnapping charge, and 0, again, to 5 years for the interference charge. You will hear her defense really put on a case saying that she was a great mother, what she did was a horrible thing, but she raised this young woman to be a really, really great young lady, and she treated her perfectly, and she was, by all accounts, a great mother. At the end of the day, though, the prosecution will say, she kidnapped this baby from a hospital and took her away from her biological parents. Case closed. We'll have to see that back and forth. Now, again, you see those 2 live feeds. We'll talk about both cases. Before we get live into the William Riley Gaul case, it looks like it's about to start up. I want to ask my guest this morning, again, I'm here with Randy Zelin. I want to ask him one quick question, Randy, before we jump into the courtroom. This killing during aggravated child abuse charge. Remember, William Riley is charged with a multitude of different crimes, including first-degree murder, but he's also charged with this thing called killing during aggravated child abuse. That's like a loophole, right? Can you explain that a little bit?
Yeah, basically, and I find it a little bit difficult in this case to swallow. Essentially, you've got 2 pieces of it. You've got a child, which is the easy part because Miss Walker was 16 years old.
Right.
And then you have knowledge of doing something that is going to be likely to cause her death as a child.
Firing a weapon into the house.
Exactly. So my problem here is he's pleaded guilty to the reckless act, which is I close my eyes. Remember, he shot from outside of the house.
Yes.
Not even within the house, into another room. Like in the Oscar Pistorius case where he shot through the bathroom door. He's out of the house.
Yeah. Yeah, that's an interesting little tidbit. We saw it in the Tex MacGyver case, ladies and gentlemen, that felony murder rule. Somebody dies as a result in the commission of a felony. Here, aggravated child abuse. They might be on the hook for murder. We have a live feed right now in the courtroom into the William Riley Gaul case. Let's go live, ladies and gentlemen.